So good afternoon, everyone. Just to remind you all that we are recording this event. Welcome to the first of the EuCML webinar series. The EuCML webinar series aims to contribute to current regulatory debates at national, European, and international level with consumer-focused commentaries. Many of the themes we will explore in the series are featured in the journal, and I thus invite you all, if you are not familiar with the Journal of European Consumer and Market Law, to go to the website to find out a little bit more, and the link has been shared with you in the comments and chat box. The journal offers an up-to-date and critical analysis of all new developments in EU consumer law and revisits some old ones as well, looking to preempt market needs and suggest some viable solutions to current and future problems. EuCML, as we know it, offers a fresh perspective on consumer law that goes beyond the traditional understanding of consumer law as consumer protection, and we therefore welcome contributions from a range of disciplines as well as jurisdictions. The journal was founded in 2012 and has now become, we hope, a must-read in the field, attracting top authors and reaching a very wide readership in the EU and beyond. Our event today focuses on online content and consumer protection, where I am joined by a very eminent panel of speakers and a very savvy audience as well. We will focus on the proposal for a Digital Services Act today, and as the reform of the current regime on platform liability set out by the e-commerce directive is being reworked, we will wonder what changes are still needed and perhaps any shortcomings that the current proposed reforms might not yet address. We are grateful to the University of Maastricht for hosting us on their Zoom platform today, and to Catalina, Goanta and Vanessa for organizing this event today. We will hear first from Ursula Pachl, the Deputy Director of BEUC. Thank you very much for joining us, Ursula, today. BEUC, for those of you who are in the know, needs no introduction, but for the others, it's the European Consumer Organization. And what we tend to also say is the consumer voice in Europe. Ursula leads BEUC's work on the digital single market, on consumer rights, on redress and enforcement. She's also responsible for horizontal and strategic policy issues and represents BEUC in the European Commission's refit platform, in the stakeholder groups of the EU Agency for Network and Information Security, ENISA, and in the European Commission's high-level group for artificial intelligence. She also coordinates BEUC's law enforcement activities. She will be joined this afternoon by Professor Vanessa, who holds the chair in civil law at Leiden University. Her research focuses notably on the regulation of the platform economy, issues concerning regulation with regard to data and technology, and financial services also. Vanessa has published widely on these topics in leading national and international journals, and her monograph entitled Legal Pluralism in European Contract Law was published last year by Oxford University Press. She will be joined also by Professor Catalina Goanta, an assistant professor in private law at the Faculty of Law of Maastricht, and one of the newest editor of EuCML. So I'll take this opportunity to welcome Catalina and our other editors to the board. She's notably managing the Maastricht Law and Tech Lab, which is a unique multidisciplinary research group with 7 computer scientists in residence at the law school. She has been a Neil Stenson Fellow and visited the University of St. Gallen and the Harvard University Berkman Center for Internet and Society. She is a non-residential fellow of the Stanford Transatlantic Technology Law Forum. Oh, I need to briefly pause. She's also very well published, as you all know. Finally, on our panel of speakers this afternoon, I welcome Professor Christoph Busch, who is Professor of European Private and Business Law at the University of Osnabrück in Germany, and a visiting fellow at the Yale Information Society Project. His research has been focused on consumer and contract law in digital markets and algorithmic regulation. Christoph is a fellow and council member of the European Law Institute, is coordinator of the ELI Digital Law Group and co-director of the project group on online intermediary platform. And that's not all, he's also a member of the European Commission's expert group for the Observatory on the Online Platform Economy, and currently a principal investigator of a research project on personalized law that is funded by the Volkswagen Foundation. This very clearly overqualified panel will also be joined by the excellent Joasia Luzak, who will add her thoughts as the discussant to this panel. Joasia is an associate professor at the University of Exeter and also the director of the Center for European Legal Studies. She's a guest associate professor at the Center for Study of European Contract Law in the Netherlands, University of Amsterdam, and her work focuses on information and disclosures, amongst many other subjects. You may also know her for excellent blog on recent developments in EU consumer law. Following Joasia's remarks as the discussant, we will be opening the floor to you and to all of your questions. My job essentially was to introduce everyone and make sure that everyone keeps to time and that you all enjoy a pleasant afternoon. So without further ado, I'm now going to hand over to our first speaker, Ursula Pachl from Busch, to share our comments. Thank you.
Yes, thank you very much, Christine, for this very kind introduction. I'm very pleased and honored to be here in this distinguished panel. And thank you very much for choosing the theme. Looking at the DSA from a consumer law perspective is a wonderful idea. And I'm really looking forward to learning also from this discussion, because it is sometimes a headache, we feel. And so let me maybe just start by first trying to manage to share my screen and my slides. So I think that should be all right. Okay. All right. So maybe before I start, I would also like to explain about the approach that we took. So as Christine has explained, we are the European Consumer Organization in Brussels, which means we are an umbrella organization. We have national consumer organizations that give us input about what they hear, what they know from consumers, how they see the market developing, and also from the testing of their products. And our specific consumer perspective was mainly on hosting services. You know, the DSA is covering a lot of different services. So it was hosting services, and within that, it was mainly online marketplaces. So this has really been the focus of all our work, not so much on content in terms of copyright infringements or hate speech or other content that you can think of. So for us, the DSA is a good starting point, but of course, quite some improvements are necessary when we want to achieve a high level of consumer protection, which we aim at. And in order to show you again where we started with our consumer organizations testing, product testing, where we saw an ever-increasing proliferation of very unsafe products not compliant with European law. The biggest test, I've shown here some examples, was a cross-country test, and 66% of 250 tested products were found to be unsafe. We're talking about teething toys for babies that can break into small pieces. We're talking about toys that contain chemicals which are up to 200 times higher than the legal allowance. We talk about smoke alarms that do not detect smoke. We talk about chargers that can catch fire and set your house on fire. So quite serious things. Maybe just to name also some companies, the test of our Swedish Consumer Council found that 26 out of 28 electronic products bought on the platform Wish were non-compliant, and other tests were also finding a lot of non-compliant stuff on eBay and AliExpress and also on Amazon. So this is just a few more of these products that you can see, but of course, well, maybe I see there is this car seat on your left corner where I wanted to draw attention to, which our member Which from the UK flagged already in 2014, in 2017, and in 2019 as not compliant and dangerous, and it was still to be found on 2020 on Amazon, and they found out it just takes a few minutes to table again or to put up front again product that has already been taken down. So we are also worried, of course, about fake reviews. There was also some testing. It's a whole industry behind. You can, for very little money, buy a lot of fake reviews. And of course, there is also a lot of scams that consumers are exposed to. Particularly, we've seen that now under the COVID pandemic, that has risen a lot. So what were our priorities on the DSA? As first priority, the question was about raising really the standard for liability, stricter liability for online marketplaces. I underline for online marketplaces, given the results that you have just seen that I presented. The due diligence obligations should cover, we thought, all relevant companies and not only the big ones or the very large platforms. We wanted to have more obligations on marketplaces to verify traders and conduct random checks. So not a general duty to monitor, which is not possible under the e-commerce directive, and we think is all right, but random checks, just like our members do that when they're looking for unsafe products. And then the other two priorities were stricter rules on how content is promoted. So I'm particularly talking about advertising and recommender systems. And then finally, and very important, always redress and enforcement in the DSA and how to make sure that consumers really get compensation or can have redress in case something goes wrong. The first point, I cannot go through all the points, but maybe just a few elements in the time that we have. So the liability, of course, was a big point for us. You know that this Article 5.3 was the first opening of the Commission. The Commission proposed to open up in a very specific case, namely when the information that is presented or the transaction is enabled in a way that the average consumer or the well-informed consumer could believe that it was the platform itself. That is a step forward, but it is definitely not enough from our point of view. Let me also say why we think that it's so important to increase liability. We see that really as a regulatory incentive for the platforms to take care, to take better care. It also reflects a lot, or should reflect the economic reality of the situation of these intermediaries who make enormous profits. We've seen it all, particularly now with the pandemic. They make enormous profits from hosting these traders. They open up the doors to consumers for these traders. In some instances, you could say they open up the door for fraudsters, but there is no liability in very rare cases and very unclear conditions. And we know from investigative journalism like Wall Street Journal that they proactively recruit even traders in China and seem to not be worried about what they do on the platform. So that was all the reasoning or part of it, and I keep that short because that's just how we would like to see the the liability regime improved. And I have to say that we were very much inspired by the European Law Institute's recommendations that have been extremely useful for us. So just to name a few of these, that we would like to see a joint and several liability for damages for consumers when the platform has failed to act expeditiously, when they have received credible evidence, for damages, contract performance guarantees, when they did not inform the consumer that it's not the platform that is the contracting party, or where there was predominant influence of the platform over the supplier. And of course, there should also be a liability in case of non-compliance with the due diligence obligations under the DSA. There is already a lot of questions here, for example, with regards to overlap with the Unfair Commercial Practices Directive, where we also due diligence obligations, and that is something which I think would be very interesting, for example, to discuss. I just wanted to also bring some good news and take advantage of the fact that you may be interested in the European Parliament's developments. They have, well, the lead MEP, who is the rapporteur in the lead committee, which is the European Parliament's Internal Market and Consumer Committee, Mrs. Schaldemose. She has taken up a lot of these ideas of stricter liability and has come with a new Article 5A, where she gives a range of liability situations where marketplaces should become liable, quite similar also to the points that I just mentioned. The question is, of course, how are the chances for making this European Parliament's position? I have to say we are not so optimistic, because there's maybe not so many political groups that would support this, but we will have to see. In any case, it is very good that such a senior MEP like Mrs. Schaldemose has already made an important step. She has also proposed other very interesting amendments. I have also to admit the report is very long. We haven't yet studied the full thing, but for example, she deletes the general exemption that we have in Article 6 for small and micro enterprises. He has also additional obligations for traceability on Article 22. So, I mean, this is quite a good perspective for the negotiations in the legislative procedure. Next point I wanted to mention is about advertising. You know that in Article 24, the European Commission has made a proposal to improve the transparency of advertising, and I don't have on the slide, but it's very important, of course, that they have also made a proposal for recommender systems. When it's a very large platform, the consumer should have an opt-out possibility not to be profiled when using recommender systems. And here, and this is really quite a significant development, already last year when the Parliament did a position on the DSA, on the forthcoming DSA, they said very clearly, and I still find this quite good in terms of unexpectedly good, that they want more stricter regulation in favor of less intrusive forms of advertising, and that people are not exposed and have to accept this behavioral advertising and this pervasive advertising. And interestingly, but not so surprisingly, the European Data Protection Supervisor, the EDPS, followed up and recommends a phase out leading to a prohibition of targeted advertising on the basis of pervasive tracking. So these are all very significant developments, and we see how these things go. Needless to say that from a consumer point of view, we support a stricter regulation. We don't have yet a fully developed position whether a ban is the right thing, in what circumstances, opt-in, opt-out, but it's certainly very welcome. Coming to the end, enforcement, there is many points to make. Of course, effective regulatory oversight and cooperation is very important with such a proposal. The first stumbling block that we increasingly identify as a problem is the country of origin principle for jurisdiction. We have ourselves, our members, I should say, very concrete experience with the GDPR, which was supposed to be a very innovative system for a European enforcement culture or an architecture to be put in place. But we have seen that it comes with major disadvantages for consumers and consumer organizations. And we are really trying to have a more flexible system. That's what we propose. That is maybe a little bit more like the CPC. I don't need to explain that. I think in this audience what the CPC is, where there is an agreement between the authorities who can be the lead, etc., etc. There is also a big question mark about the relationship between the governance system of the DSA and CPC. We of course would be very interested that we see a not affected CPC system, but I also have to say we haven't seen yet the proof of the pudding, whether the CPC is really going to deliver. So there is still a lot pending. And then the question, could consumer authorities be designated as a coordinator under the DSA? But we also have the requirement of independence there. And as we know, consumer authorities are not required to be independent. And then just to mention very nicely that, of course, nicely from our point of view, that the DSA is already foreseen to become part of the Representative Action Directive Annex, and consumer organizations could therefore bring collective redress. And this is also one reason why, of course, we would really need clarity on liability rules. Last slide. Well, the DSA is a piece of a puzzle, and a puzzle that we all want to bring together to have a fairer and safer online environment. Consumer law, the Omnibus Directive. I didn't talk so much about general product safety, but of course that's a very important element to look at. Just to mention, on 30th of June, the review of the General Product Safety Directive will be tabled by the European Commission, market surveillance, product liability, and of course AI regulation. So this is quite a dense, let me say, the density of legislation is also not easy to see what is the right way forward. Thank you very much for your attention. Thank you.
Great, thank you so much for sharing your thoughts and position and being on time. That's a fantastic start. So I'm now going to challenge Vanessa Mack to be able to keep to time too. And we now hand over to hear her thoughts.
Thank you, Christine, and I will do my best. I will also share my screen with some slides. So you should be able to see those now. And Ursula, thank you for a great presentation. I like the fact that you pick up on some very concrete points where the DSA could be improved to ensure better consumer protection. I think there's a lot for discussion in there, and what I'm hoping to add to that discussion is the broader picture on liability, what could have been done and what is missing from the proposal, to my mind. Perhaps also good to say that the contribution that I wrote with Christoph Busch will appear in the next issue of EuCML or journal, and some of the points that we discuss here will be elaborated in that too. Now, I'll briefly set the stage. So what does the DSA aim to do? And then move on to how it improves or does not improve upon the e-commerce directive, which was one of its stated aims. I will then say something about monitoring and verification, as well as enforcement, which I think fits nicely with the points that you just made, Ursula, and then conclude with some further points for discussion. Now, I think it's important to bear in mind what the DSA aims to do, in particular in a webinar that focuses on consumer protection, because the proposal itself is actually aimed at goals that are broader than consumer protection. If we look at those goals, then the Commission emphasizes the protection of fundamental rights in the digital space. And that means that free speech and stopping the dissemination of fake news are central goals that this proposal also seeks to safeguard. And that is important if we look then at consumer protection, which is based in market regulation. That is actually a different issue, yet the proposal seeks to deal with them both. And perhaps that also explains why liability rules are missing. I'm very glad to see that the European Parliament is thinking of adding those, but it's still sort of a balancing act of connecting those two different types of markets. I'm going to focus then on online platforms, which is one issue covered by the Digital Services Act proposal. If we look at the definition, we see that other types of intermediary services are also covered, but sort of like an onion, the rules are more specific than for particular services. So online platforms and the very large online platforms. And what they do is they host, so they actually store information and then disseminate it. And that also puts them in a position to play an active role in monitoring the information that is being posted. So this is the picture of the onion. And then the question that I would like to put to you is now, what does the DSA proposal do in terms of improving the protection that consumers could derive from the e-commerce directive? And the quick answer to that is not a whole lot. But if we do look at the monitoring system that the DSA proposals, at least on the sort of in the office of online platforms, they are obliged to do more to verify who is trading on their platform. So what does the DSA say? It says it encourages online platforms to voluntarily monitor what information is being posted on their platforms and to take action if that is illegal information. That's not an obligation. So that is one aspect where, to my mind, liability rules could be stronger than encouraging platforms. It fits, of course, with the e-commerce directive. So if we look at Article 5 of the DSA, that mirrors the host exemption that we know from the e-commerce directive, that says that there's no obligation for an information service society provider to actively monitor the information that's being posted. However, they are obliged to remove illegal information if it's brought to their attention. And they can be held liable if they don't do that. The Court of Justice has interpreted that and has said that this liability exemption does not apply in cases where the platform takes an active role in structuring the presentation of products on their website. And then, of course, the question is, well, what is an active role and in what circumstances does a platform become liable? And it could also be a provision that discourages platforms from actively monitoring. So the DSA proposal tries to, while keeping this as a starting point, tries to encourage platforms to actively take a stance on monitoring the information. I will say a bit more about that. One aspect here that is important is to which platforms this rule applies. And that is a difficult question that the Court of Justice has given several judgments on in relation to the e-commerce directive and the definition of an information society service. Unfortunately, the DSA doesn't do anything to give us further guidance. So that means that we're still using the case law of the Court of Justice as our starting point. And what that case law says is that we need to distinguish between different types of platforms. There are the platforms that integrate services offline and online, where the platform plays an active role in connecting actors who otherwise would not have met and therefore the platform creates a new market. And as a second element, the platform has a decisive influence on the terms and conditions that apply between the users. Now, Uber is that kind of platform, and that means that it doesn't fall under the e-commerce directive, and that national jurisdictions can regulate the platform under their national laws. Other types of platforms like Airbnb are not considered to be integrated service providers and therefore can fall under the e-commerce directive and benefit from the host exemption. And that is the type of platform to which the DSA proposal also applies. That leaves us with a group of platforms that's not covered, and one could say an unequal playing field where it's not justified why certain platforms fall under the DSA and others do not. It would have been good, and perhaps there's still an opportunity for the European legislator if the definition in the e-commerce directive was reconsidered and if clearer stance had been taken on the connection between online and offline services. So that's my first point. Then there is one spark of light here, and that's the provision that Ursula also already mentioned, Article 5.3, where an average consumer who reasonably relies on the presentation of the platform could still hold the platform liable. To my mind, that is only a first step, and it would be great if we could have further liability provisions, for example, based on the Unfair Commercial Practices Directive. That's a point for further discussion. Very briefly, the Unfair Commercial Practices Directive sets a general norm under EU law, but leaves the remedies to national law. And that means that there are several questions that still need to be answered if a platform can be held liable. For example, can a certain action be attributed to that platform as a trader under the Unfair Commercial Practices Directive? That is a question. I think it's difficult because a platform is not necessarily an intermediary acting on behalf of a trader or a consumer. That's a private law point. I don't know if everyone in the audience is a private lawyer, but if you want to use the Unfair Commercial Practices Directive as a basis for liability, you will have to deal with those questions of national law. Now, what does the DSA do? It doesn't focus on liability, but instead of that, it seeks to make sure that there's a monitoring system behind the scenes where online platforms monitor who is active on their platform and that they can be traced in case they, for example, post misleading information about products. Part of that scheme are trusted flaggers, so certain entities who can be trusted who highlight when there is illegal activity on the platform and then oblige the platform to take down that information. And for very large platforms, there's an obligation to monitor systemic risks. And that means that if they see that there's illegal information on that platform, they have to actively take action to stop the dissemination of that information. Coming back to what I said at the beginning of this presentation, that systemic risk monitoring fits very well with stopping the dissemination of fake news and other illegal information, but it's perhaps not the best mechanism to protect consumers in an online marketplace. So perhaps a question there, do we need more to protect consumers in the marketplace? And should the DSA become more specific in that regard? What we do have is now Article 6, which makes clear that platforms who do actively monitor are not then liable or lose the host exemption protection. And that is a provision that is copied from the US Good Samaritan rule, So that is, again, a first step, but it's not a very strict liability rule. Also, in terms of how monitoring takes place, the DSA could, in any case, be more clear and perhaps also enable the random checks that Ursula already mentioned. If we look at the text of Article 7, we see that there's a small change in the wording in comparison to the e-commerce directive, and that suggests that it's no longer possible to do those very specific checks. It is unclear whether that was intended, but if that is the consequence, then it would be very good to revise the wording here and to enable those specific checks, in particular where the technology is available for platforms to do that in an efficient manner. Then I come to compliance and enforcement. And I have some questions here and perhaps some suggestions for the discussion as well. So the DSA looks at digital services coordinators to monitor compliance and to take action for enforcement. There is that question, who can be a digital services coordinator? And one question for the discussion might be, could it also be something like an authority for consumers and markets? So some member states, like the Netherlands, have combined authorities that monitor the compliance of consumer law, but also of competition law, and that can take action for enforcement. And they could play a role in this. I think they would be better placed, if I'm just looking at the Netherlands, they would be better placed than, for example, the authority that monitors compliance with data protection regulation. There are also issues there concerning resources. The data protection authority is completely overwhelmed and cannot probably not take on additional tasks. And if we look in particular at online marketplaces, then perhaps an authority like the ACM could take this role. The relation to the CPC is also a question that I had. One thing that could be of interest is that the DSA could complement some of the enforcement rules under the CPC, such as the power to order a hosting service to take down information. That is quite a strong power. It actually means that a website can be taken down. And it's also implemented in such a way that there needs to be a judge considering a specific order and looking whether it's proportionate to go as far as taking down a website. Now, also wondering how the DSA relates to that. But if that kind of enforcement powers can be given, that could be a very strong tool, besides liability rules for individual consumers to ensure the collective protection of consumers. Concluding then, I believe that the DSA offers us a promising framework for monitoring traders' actions and information on online platforms. But I believe the proposal would be much stronger if liability rules were added for individual consumers. That's one conclusion. Another one is how can we actually use the same instrument to monitor free speech and issues concerning fundamental rights in the same proposal with the regulation of online marketplaces. I still find that difficult, and perhaps it's too late now to make the proposal such that it might become two proposals dealing with different issues, but it is a concern and it's something that I think needs to be tackled more explicitly by the European legislator. I conclude with that, and then I'm going to hand back to Christine for introducing the next speaker, and thank you for your attention.
Great, thank you very much, Vanessa. Also managing the challenge of keeping to time was sharing a lot of thoughts and things that we can discuss. I invite participants, whilst we're not going to be taking questions whilst we are doing all the talks, please feel free to put anything in the chat, questions, comments, and react live. I'm now handing over to Catalina to continue the exploration of the DSA that is now well underway, and 15 minutes to you.
Thank you so very much, and allow me to express how honored I am to be in this distinguished panel, and also how happy and excited I am to join EuCML. It's really been such an amazing academic family, so I'm very grateful for that. I'm going to continue the exploration of the DSA. Hopefully now you can see my full screen as well. I'm going to continue the exploration of the DSA with a paper that I have recently, to present to you, a paper that I have recently written with Caroline Kaufmann, who unfortunately really wished to be here today, but could not due to teaching obligations. And I would like to use this opportunity to just elaborate even further on some of the additional challenges that the DSA might present when it comes to the links to the existing consumer acquis. In our paper, we have 4 main points, and this is something that I'm not going to explore in great depth because I will also link the paper in the chat. However, just to give you a very brief overview, first of all, what we do in the paper is we explore the way in which the DSA links to the consumer acquis. So this is one of the points that I'm going to focus on today, since the DSA is supposed to bring about these transparency duties and is supposed to really create more accountability and transparency when it comes to also third parties, so not just marketplaces or very large platforms. However, a quick scan through the current version of the DSA shows that a very specific link to additional instruments, such as Vanessa was just mentioning, the Unfair Commercial Practices Directive or the Consumer Rights Directive, is not immediately obvious. So then, of course, a lot of questions arise. How exactly will these new transparency duties be fitting with the information duties that exist in instruments such as the Consumer Rights Directive? The second point, and once more, I'm not going to go into this because I think Vanessa has already really wonderfully explained the gist of the matter. So, of course, the DSA is taking the discussion on intermediary liability and moving it into a new era of digitalization. However, it is doing so by staying perhaps true to the way in which the e-commerce directive has been regulating liability in this field. What is interesting is that apart from the actual words that are currently used in the DSA, the policy discussions around the way in which intermediary liability is supposed to be shaped in this instrument are shaping the fact that we are going to move from a model of notice and takedown to a model of notice and action, which, in spite of the goal of the DSA to create more transparency, is, especially when we're speaking about recommender systems, might lead to even more opacity because of practices which some of the members of the audience might be familiar with in more social media oriented work, such as shadow banning. So there are a lot of questions to be asked there as well. And the third point, similarly raising a lot of questions as well, is the problem that any kind of disputes that arise on platforms are now very much considered that are going to be the responsibility of said platforms. So in a way, what we call in the paper that this phenomenon is leading to is this outsourcing of solutions to private entities. Indeed, it is true that, especially with this is what we see also in other instruments in the consumer acquis, that there is always a reference to the fact that access to justice and consumer rights should not be affected. However, here we're not speaking necessarily about a legal lack of cohesion, but we're speaking about the difference between the legal and the factual situations that can arise on platforms. When it comes to the fourth point on digital enforcement, we can also see that in the fourth chapter of the DSA, there is a lot of discussion about the implementation of the DSA. So Vanessa already touched upon that. And what I would like to do in this presentation is just give you some glimpses and some very clear examples of why digital enforcement really should be on the agenda of every consumer lawyer in the European Union, and not only in the decades to come. come. So as I was mentioning, what I'm going to do in this presentation is going to focus on 2 points. First, the internal coherence discussion, and second, the digital enforcement point. I think there are participants in this audience who have already seen this example that I'm going to give right now, but it is an example that I have collected proudly from my own Instagram account. And with this example, I would like to also set the scene in a more practical way. This is Instagram, and as you can see in the image to the left, that is a pair of sandals. If you tap on the pair of sandals, you will see that there are going to be product descriptions, and if you tap on the product description, you can see that you can visit the website that the trader of these sandals is going to offer them to the consumers who see this as an image on Instagram. If we tap some more, so 2 more taps away, what happens is that you can see that that are then redirected to the website of the trader. But if you look at the image to the right, you will see that shop is actually still on Instagram. So you never leave Instagram, even though you are browsing and you are going to the shop of this third party. In a nutshell, what this shows is the rise of the phenomenon, which Christine has already spoken about in her own research, of social commerce. So what we see is that on social media platforms, we have examples of situations where social, commercial, and political speech come together. And they come together in such a way that it becomes very confusing for consumers to understand who exactly are they concluding a contract with, who exactly has duties towards them. And to be very honest, also in the conversations that I have been having with Caroline, I believe that this confusion can sometimes even spill into the academic world, because the complexity of the networks that such platforms are able to give rise to and to amplify will definitely be challenging the current shape of the consumer acquis. An example, and I believe that this was referred to earlier as well, an example in this respect, and the DSA has a chance to solve the problem of this triangle where we have a platform and then we have another trader that is offering goods or services to a consumer on this platform, is Article 22 of the DSA that speaks about the traceability of traders. If you look specifically to the provision in the second image, point number 7 shows that the DSA is offering an opportunity for platforms to really be held, have a legal regime basically to be held liable for the fact that they actually need to show the interface to consumers in such a way that all of the information duties that exist in the consumer acquis can be complied with. So I believe we were hearing also a lot of references. I think Ursula was mentioning a lot of references to marketplaces. I think the question for us, and perhaps we can also take this in the discussion, the question for us should be also, with the rise of social commerce, who exactly are these marketplaces? Are we speaking about the marketplaces like Amazon, eBay, Bol, that we originally associate with the notion of a marketplace? The notion of a marketplace that brings together sellers and consumers, and that a marketplace that you go to because your primary goal is to conclude a transaction. And obviously, marketplaces have their own particularities, because then you can have sponsored posts, you can have fake reviews, and these are always also ways in which consumer intent can be manipulated. However, what I would like to really emphasize is the fact that when it comes specifically to social media platforms that are right now, according to market research trends, really the next marketplaces, the question of disclosure becomes even more prevalent. If we look at the general terms that eBay or Amazon or Bol use, because of the fact that there is going to be sometimes there is going to be an overlap between the identity of the seller, of Amazon as a seller, and the identity of Amazon as an intermediary, There has been perhaps a more practical adoption of, for instance, disclosure duties by these platforms, and they are offered to consumers in the contracts, for instance, even by creating an account and by engaging in transactions with the platform itself. However, on social media platforms, this becomes even more complicated. So from my perspective, I think the DSA is really missing out on an opportunity to clarify how disclosures can be made not only in the light of the relevant rights that consumers have, for instance, according to the withdrawal right provisions in the Consumer Rights Directive, but also with respect to what platforms themselves need to disclose to consumers and not just to authorities or to traders. If we look at Article 22, Article 22 is very much the idea that platforms, online platforms, are supposed to have their online repositories of traders, and that this type of transparency that is required from traders, that in the name of traceability, is not necessarily something that is supposed to be communicated to consumers, which is in a way very dubious in the light of how consumer protection in online commerce has been developing from the perspective of making sure that traders send and have very clear information towards consumers. So here, the inconsistency that we explore in the paper actually deals with the fact that on the one hand, we have the disclosures that are by now so famous and infamous, depending on which continent you regard them from, when it comes to the information duties that traders have towards consumers. And now the fact that intermediaries could really play a role in the conveyance of this type of information, not only from the perspective of existing rules, but also from the perspective of rules that the DSA is supposed to bring about in a novel way, like this particular article. When it comes to digital enforcement, so this is just some food for thought also for the discussion. When it comes to digital enforcement, let me just build on what Ursula was mentioning earlier. So the CPC network is now having its second e-enforcement academy group, and in the e-enforcement academy, especially in the light of the white paper on artificial intelligence that we saw from the European Commission early last year. But also in the light of new regulations such as the AI regulation, we see that there is, not only in the European Union, but also abroad, a massive focus that enforcement needs to be digitalized. And digitalized enforcement leads to some degree of surveillance. And that is, I think, a very important concern that we need to keep in mind, even if we're speaking about consumers. So traditionally, if we speak about surveillance in the way Shoshana Zuboff refers to surveillance, we have companies that have been traditionally focusing on consumers. We have had states traditionally focusing on citizens. And now we see that basically there are relations that whereby states are going to hire companies to focus on citizens, and perhaps they will also focus on consumers in the future. Let's take the example of maybe trying to figure out if fake reviews exist on Bol.com or not. We can, like I said, go into this in the discussion as well. Now, I think that there is a great opportunity also for scientific work to be done at the intersection of law and technology when it comes to digital enforcement. But I think that this also needs to be developed in a very cohesive and in a very solid way, because I think it would be very difficult to see a European Union that acts in multiple speeds because of the different levels of digitalization that authorities have been able to acquire so far. An example of what digital monitoring can look like is a project that is led by one of our PhD students, Constanța Roșca, at the Law and Tech Lab, on replicating the study together with Gune Shakar, who is one of the original authors as well, replicating the study done at Princeton University on the detection of dark patterns on e-commerce websites. So doing this and coupling this with the discussion relating to what exactly would be a dark pattern from the perspective of the Unfair Commercial Practices Directive. This is an example. Examples of dark patterns. So basically digital monitoring would entail web scraping, data analysis, but also focusing on priorities. What exact practices do we want to investigate on these platforms, on these online platforms? How are these priorities set? Are these priorities set at central level, at European level? Are they set by national authorities? There is a framework for cooperation under Chapter 4 of the DSA. I believe that perhaps it would be very necessary to just have additional guidelines and additional rules on the transparency of also how these investigations can be done. Another, and my last point, and with that I will conclude, future issues that to be discussed. I think Ursula mentioned also the advertising dimension. We can see that Facebook is really one step ahead of the DSA. So this is how transparency and advertising looks like in the light of Article 24 of the DSA. There's an ad library that can be used to track all the ads that are bought on Facebook in different countries for different issues. So for instance, you can have all ads, but also specific issues like elections or politics when it comes to ads. However, the question is, how are we going to also look at native advertising? And the DSA has this massive blind spot where native advertising in the form of influencer marketing, which is something that Christine and I and Joasia, I believe, will be working on. The question is, what does the DSA do in terms of bringing about transparency also for advertising other than the one promoted by platforms? So these are, again, a lot of questions, very few answers right now, but this is exactly the goal of this webinar, to try to start exploring these issues with concrete examples and with multiple perspectives on the DSA. That was, I think, all the time I had. So thank you very much, and I really look forward to the discussion.
Thank you very much, Selena, for all of those thoughts again. And we're going to move swiftly on to our last panelist, Professor Christoph, who will share his comments before we move to our discussions. Thank you.
Thank you very much, Christine. I would also like to share a few slides with you, and I hope that it's working. So, in my short presentation, I would like to focus on one particular aspect of consumer protection in the platform economy, which is the liability of online marketplaces for defective products. And I will address this topic from a comparative perspective, comparing recent developments in the US and Europe. So I will try to look a little bit beyond the DSA. The starting point is the observation made already by Ursula Pachl that the rise of online marketplaces such as Amazon and eBay has not only increased consumer choice, but also enabled the influx of unsafe and defective products to US and EU markets alike. Recent market investigations, and here you see a few headlines, on both sides of the Atlantic have provided ample evidence of this problem. Now, it is a matter of controversy whether and how product liability rules, which have been designed for traditional distribution chains, can be applied to online intermediaries. In a growing wave of cases, courts across the US have been asked whether Amazon is actually responsible under state product liability laws for products sold by third-party sellers. In a number of cases, Amazon was not held responsible. Courts argued that Amazon cannot be considered a seller and therefore is not liable because Amazon never took title to the product at issue. More recently, however, the tide is starting to turn, and courts from Pennsylvania to California have held Amazon liable for third-party products. A well-known case is the Bolger case from August 2020, where Amazon was held liable for an exploding laptop battery that was shipped to a customer via an Amazon fulfillment center. The latest addition to the line of case law is Loomis against Amazon, a case decided by the California Court of Appeal on April 26th this year, where Amazon was held liable for a hoverboard that Mrs. Loomis had bought for her 9-year-old son, Ethan, and which exploded just a few days after Christmas and set their family home on fire. Interestingly, in this case, the product was not shipped via a fulfillment center, but was shipped directly to Mrs. Loomis from the third-party seller. So in this case, the Loomis court extended platform liability beyond what was held in Bulger. Now, as a result of these diverging cases, the map of product liability for online marketplaces in the US is looking a bit patchy, as you can see here. And there are further pending cases in Texas, at the Texas Supreme Court, for example. There's another prominent case. Now, how would such a case like Bulger or Loomis be decided in the European Union? Coming back to our topic. The relevant EU law, of course, is the Product Liability Directive, which, as you know, dates back to 1985, a time when there was no commercial internet and certainly no online marketplaces. Therefore, the liability system of the directive is based on the very traditional supply chain model where a product reaches the consumer via a pipeline from the producer via an importer and a supplier. Consequently, the directive imposes product liability primarily on the producer and the importer, and Article 3, Para 3 of the directive extends liability to suppliers where the producer or importer cannot be identified. This model worked reasonably well in the 1980s, but it no longer reflects the reality of digital markets, which look more like this, or maybe like this, or we could add the social commerce example that Catalina gave us. Now, the structural change of online retail raises several questions. Can a marketplace like Amazon be considered an importer under the Product Liability Directive? Would the answer be different for a fulfillment by Amazon case like Bulger or a fulfillment by merchant case like Loomis? And finally, does the e-commerce directive or a future Digital Services Act shield Amazon from liability? Would it provide a liability shield? Interestingly, in contrast to the growing wave of cases in the US, there is no prominently reported case law on these questions in the European Union, at least to my knowledge. But there is an emerging debate among scholars. Here are just two examples of recent papers dealing with these questions, one by Paul Verbruggen and another one by myself. Regarding the question whether the e-commerce directive provides a liability shield against product liability claims, one could possibly refer to the Care Optica decision, in which the court held that the e-commerce directive only applies to the online part of a transaction, but not to the subsequent supply of goods. And there is similar language in the DSA in recital 6. So from this perspective, one could argue that product liability claims against online marketplaces are not about liability for online content, but rather about putting defective products into the stream of commerce. This would be very much in line with the reasoning of the California court in Bulger, where the court argued Bulger's claims are based on Amazon's role in the chain of production and distribution of an allegedly defective product. The fact that some content provided by Lenoge, that was the third-party seller, was posted on the Amazon website does not automatically immunize Amazon for its own choices and activities unrelated to this content, which is the fulfillment service provided by Amazon. And therefore, Amazon could not rely on the liability shield provided by Section 230 of the Communications Decency Act, as was argued by Amazon. One could also argue that Amazon is playing an active role and is therefore not benefiting from the liability privileges under the e-commerce directive or a future DSA. This argument was actually raised by the Advocate General in a recent trademark case, so not a consumer law case, but a trademark case, Coty against Amazon. But this would then still leave the question open whether Amazon or any other online marketplace can be considered an importer or a quasi-importer under the Product Liability Directive. Meanwhile, so for the time being, there's a lot of legal uncertainty regarding the application of the Product Liability Directive to online marketplaces. Meanwhile, the EU legislator has moved forward in a different area, but which is closely related and which was already mentioned by Ursula Pachl as well. The new market surveillance regulation, which will be applicable from July 16, so less than 4 weeks to go, requires sellers based outside the European market to designate a point of contact inside the EU for market surveillance authorities. That's the so-called responsible person who has to be in the EU. And the responsible person can be an importer, an authorized representative, or a fulfillment service provider. Now, interestingly, Amazon has turned this new regulation into a business opportunity and now offers what they call the Amazon Responsible Person Service. For 25 euros per month, you get Amazon to be the responsible person for your products. The recent tightening of product safety regulations, as you can see here, is complemented by the Product Safety Pledge, a voluntary commitment of several major online marketplaces. The signatories of this pledge committed to take actions against unsafe products that go beyond what is already required under EU law. Now, there are conflicting views about the effectiveness of the Product Safety Pledge. Well, the European Commission praises the progress made under the voluntary pledge. Consumer associations take a somewhat more skeptical view, I think. Against this background, there were high expectations when the European Commission presented its proposal for the Digital Services Act last December. And just a few weeks before, the European Parliament called on the European Commission to actually address the liability of online marketplaces in cases where the marketplaces have a predominant influence over suppliers. And those of you familiar with the ELI model rules may see that this could have been actually inspired by the work of ELI. Now, the European Commission did not follow the suggestion of the European Parliament and did not include a positive liability rule for online marketplaces. Instead, the proposal more or less copied the liability privileges from the e-commerce directive. The most interesting addition to this e-commerce directive system is Article 5, Para 3, which has been mentioned already several times. And as you can see here again, this provision actually contains a carve-out from the liability shield in cases where an average consumer is led to believe that the products or services are provided by the online platform itself or by a third-party seller under its authority or control. You might call this the apparent control rule. This raises the question how such apparent control shall be assessed. The draft IMCO report that was published just a few days ago suggests to add a list of indicative criteria for assessing the degree of involvement of a platform operator into the transaction in order to identify whether there is this apparent control. And here again, the ELI model rules, if I may say this, might have been a source of inspiration if you look at these two lists. Now, the bottom line is, at this point in time, the DSA contains no positive rule on product liability for online marketplaces. The DSA rather follows a different approach based on the Know Your Business Customer rule, which has also been mentioned before, and which requires online marketplaces to verify the identity of traders who offer their goods or services via the platform. And there is even an interesting link, a little bit hidden in Article 22, an interesting link between the DSA and the market surveillance regulation. Because Article 22 DSA requires online marketplaces to obtain the name and address of the responsible person within the meaning of the market surveillance regulation in order to verify that traders on the platform actually do comply with the market surveillance regulation. Now, if you compare these two approaches in the US and in the EU, you might say that the US and the EU are following two different paths. The US seems to focus on indirect regulation through product liability, and the EU seems rather to emphasize direct regulation through public enforcement of product liability rules, product safety rules, excuse me. Now, if the EU decides to follow the US approach and introduce product liability rules for online platforms, it might take some lessons from the attempt to introduce at state level a piece of legislation on product liability of online marketplaces. And I'm actually talking about this California Assembly bill that was introduced last year in February by Assembly member Mark Stone, and that provided for product liability of online marketplaces. Now, as one would expect, this stirred a controversial debate, and unsurprisingly, a broad coalition of online marketplaces initially opposed the bill. However, the debate changed after the Bolger decision, which came in August 2020 and which held Amazon liable for third-party products. Now, in a surprise maneuver, Amazon started to support this bill under certain conditions. Amazon said, we're supporting this bill if it applies equally to all online marketplaces, also those who do not provide fulfillment services. And this, as you can imagine, caused an outcry from other online marketplaces in particular. So Amazon backed this proposal, and then followed the outcry in particular from eBay and Etsy. And one of the most vocal critics of this proposal was actually the Etsy CEO, who argued that Amazon is actually trying to wipe out its competitors by backing this California Consumer Protection Bill. The argument was Amazon would be able to shoulder this liability and to pass on the financial burden to third-party traders, whereas other online marketplaces would not be able to do so. And this opposition that was stirred by Etsy and eBay was successful because at the end of August 2020, the California Assembly shelved the bill. The bill moved not forward. But that is not the end of the story. It's almost the end of my presentation, but not the end of my, not the end of the story, because the bill was reintroduced in February this year with a slightly different wording, and it now imposes product liability on online platforms that are doing two things: transferring communication between buyers and sellers and processing payments for transactions. And that's a very wide scope, and we will see how this debate will continue. I finished, that's my last slide, with some food for thought for the discussion, whether the regulatory design of product liability rules should focus on physical control over the products, or whether algorithmic control would be sufficient, whether asymmetric regulation should be applied, like in the DSA, exempting smaller marketplaces, which would be a deviation from the principle that consumer protection applies equally to big and small sellers, and what the effect on competition and market structure, especially between those platforms that offer fulfillment service and those that don't, will be. Thank you very much. There's some further reading, and I'm looking forward to the discussion.
Thank you, Christoph. So without further ado, it's now nearly time for all of you to be able to share your comments and put your questions to the panel. But before we do that, and to kick us all off, I will invite Joasia to share her thoughts as the discussant for this panel. Joasia, the floor is over to you.
Thank you, Christine. I won't take a lot of time, as I basically see my role as indeed starting the discussion and providing a few maybe additional comments here. I listened to all 4 in-depth presentations with great interest. They gave us different insights on what could be regulated either farther or differently in the DSA. And I think the presentations complemented one another very nicely, but it should also be pretty clear to our participants in the workshop by this point that generally a lot could be improved around the draft DSA. So the few points that I wanted to raise were that, well, firstly, I would also be inclined to criticize the proposed draft DSA as an instrument of consumer protection, as I think it doesn't sufficiently take into account the rights of users of digital services. But I think that perhaps we should start by acknowledging that digital services raise a lot of issues in different areas of not just consumer and competition law, but as has been also mentioned by Vanessa, for example, also in Catalina, also media law, fundamental rights protection, and so on and so further. And this breadth of issues that arise, as well as of different legal rules that may currently regulate them, could perhaps justify some omissions in the scope of the DSA, or maybe be the reason why the Commission would choose for a light touch approach in a way. Because the first question that I think we should ask ourselves to continue the debate would be, could we actually legitimately expect that the European legislator adopts a comprehensive horizontal measure addressing all these various issues that digital services cause? I think the concept was very ambitious, but in a way, I think it was doomed to be a failure already when they attempted to address such diverse issues as protection of fundamental rights in one instrument on one hand side, and on the other hand side, the problem with unsafe products provided in the online environment. And I wonder whether we could expect to have one comprehensive instrument, so the DSA, to address the issues of, well, not just hate speech, protection against hate speech, protection against unsafe, dangerous products online, but also things that have not yet been mentioned, like protection against dark patterns, unfair contract terms and conditions of online marketplaces, asking the online marketplaces to introduce further transparency obligations, even further than what has been provided in the DSA draft. So, for example, to ask for consumers' explicit consent to the contract's conclusion, not just with the specific trader, but also with the platform. And Catalina, in her paper with Caroline, specifically addresses the issue of the lack of coherence between different instruments that we have currently, and that the DSA actually likely will increase this lack of coherence. Christoph and Vanessa in their paper also advocate for the DSA focusing on tackling one issue at a time. So I think it would be good to discuss a bit more what scope of this act would be preferable to us actually. What should be prioritized if the Commission, if the European Parliament will need to now prioritize certain issues? Now, the second issue that I wanted to raise expands a bit more on the purpose that the DSA attempts to fulfill. when we identify these various discrepancies between the objectives of the DSA and the mechanism it chooses to try to achieve them, I think we also actually skip over the definitions. DSA suggests to me, and likely any average consumer, that it will cover, in the scope of its provisions, digital services, right? It's a Digital Services Act, unless some digital services are specifically excluded from its scope. But instead, the DSA applies only to online marketplaces. And Catalina mentioned that there may be an issue whether these online marketplaces will cover social commerce actors. I think from what I've read in Vogue's position paper, there was a hope expressed that online marketplaces actually will be broadly interpreted and thus will also apply to social media services. But that even such a broad interpretation does not take away from the fact that the DSA really aims to apply only intermediary online services. So even if we understand it broadly, it still covers only intermediary online services and not digital services as such. And thus, I wonder whether we should not even expect the name of this act to be changed. And should we simply start accepting that digital services are now becoming synonymous with intermediary digital services? I wouldn't be in favor of such an interpretation because I think we do have also rules on platforms and platforms liability. And that to me is more representative of intermediary digital services. And when we talk about the digital services, we should leave the scope also for other players on the market and regulation of these players. And the issue that Christoph and Vanessa also outlined, and we could hear it from Vanessa's presentation, of the lack of sufficient distinction between platforms offering a combination of online and offline services and what qualifies them to fall within the scope of the DSA as intermediary online marketplaces. Now, the third point I'd like to make relates to the objectives set for the DSA of protecting fundamental rights in digital services. There was a lot of concern expressed about the e-commerce directive, internet users from hate speech, cyberbullying, aside not ensuring product safety. And all four presenters have criticized the DSA for not doing enough to reach these objectives, but I wonder whether we could try to play the devil's advocate here and provide to our participants some examples when DSA may actually reach these objectives, as it's supposed to focus actually on this protection of fundamental rights. So do you think, for example, that the proposed system of flagging illegal activity content to online marketplaces, whether by trusted flaggers or other users, as proposed by the DSA, has a chance to protect users against hate speech and could guarantee more protection of fundamental rights in the online marketplace? Could we at least hope for some improvement in this area and that the DSA can reach this objective? Despite, of course, this being perceived likely as part of the privatization of internet governance, as Catalina's paper is also warning us about. Could it be effective at least? Now, my fourth comment addresses the issue of the liability exemptions, which are obviously a controversial repetition of the e-commerce directive that most of you also addressed in your presentations. Vogue, in its position paper, has mentioned that what we really need is this adoption of positive liability of online marketplaces for damages, non-performance of the contract, guarantee issues. And there's a recommendation that the online marketplaces should be jointly and severally liable if they fail in their due diligence or information duties, or they exerted predominant influence over transaction suppliers. Now, Christoph in his presentation looked into US approaches and posed the question whether this indirect regulation of liability through product liability rules could not be a better solution. So here I again would want to ask maybe and start a discussion on the topic whether we need to discuss introduction of different rules on liability depending on their risk and harm to consumers. So if we talk about unsafe products, perhaps we should look for different rules on liability than when we talk about breach of other obligations of the online marketplaces. For example, with regards to regulating content more than the products that are being sold on them. And if we talk about the regulation of liability of unsafe products, and we are thinking that we could apply product liability directive there, I wonder whether the solution could not be to see the online marketplaces as sellers, like some states in the US do, but rather to extend in the new version of the product liability directive, which we are all hoping to receive soon, to extend this possibility that if a transaction is concluded by through an online marketplace, the person that still remains liable in the first place would be the producer. If the producer cannot be identified, it would be the importer, trader, and so on. But if that person cannot be identified, then it would be the platform for which the transaction is concluded, because that would be a a reasonable consequence of the platforms breaching their traceability obligations and ensuring that the person who puts the product on the platform is identifiable and then can identify the producer. So that could still leave the consumer with a reasonable route to remedies for being provided unsafe products and limit somewhat the burden for the platforms. They would still have to do their due diligence basically and only be liable if the due diligence isn't fulfilled. And finally, I wonder whether we should ask this DSC proposal to explicitly recognize the contractual relation between online marketplaces and consumers, because this still doesn't happen, and I think it could lead to the easier introduction of disclosure duties for them that Catalina mentioned. If we explicitly finally recognize that when a consumer concludes a contract for an online marketplace, the contract may be concluded not just with the trader for a particular product, but also with the platform for their services, that could lead to the automatic introduction of additional disclosure duties, application of the CRD framework, and so on. So shouldn't we expect the DSA to actually approach this issue as well? That would be my contribution, and I'm looking forward to your answers.
Great, thank you so much, Joasia. So I saw a lot of the panelists just frantically noting things you were saying and preparing their response. But before I give them back the floor, I think I'd like to invite some questions from our participants so that we don't actually run out of time to hear their views and their comments and their question. And then I will reopen the floor, either if we have pointed questions for a person to that person, and then you can perhaps wrap up some of your comments back to Joasia, or we'll see how it goes. So as the audience perhaps prepares to ask questions, if you're a bit too shy, you can put a comment in the chat box and I will give you the floor. But for those of you who know us, you know we're a friendly bunch, so you can, without hesitation, just turn your microphone on and start talking when there is a little silence. If not, whilst this is happening, I will invite first, perhaps our first panelist to react. So I give you 1 minute, the audience, to ask a question now. Anyone wants to take the floor? Anyone who's trying to find the unmute button? Okay, well, whilst we sort out this technical glitch, or you put your question in the chat, perhaps I will invite Ursula to comment first on what she's heard and perhaps answer some of the points that clearly were well within your remits from what Joasia has discussed. Thank you.
Well, thank you so much, Christine, and thank you, everybody. I mean, those were so rich contributions and so interesting that I think they really contain so much food for thought. I will keep it short and because I have really taken a lot of notes for further reflections. Maybe just one point that I find will be certainly if I may say, a battle in the legislative procedure is this question of the definition of the online marketplace, which is not included in the DSA. And I think the point that Catalina made is a very, very relevant, because it's this social commerce, as you called it, which is the future probably. And it's not even only these social media platforms, but you have probably followed what WhatsApp is trying to do these days. And we will soon have it on our messenger services, and we will have it everywhere. And our position is clear that these platforms should be understood as also online marketplaces and should have the same obligations. But of course, I mean, we know that they all make the argument that what does not happen on their platform, and that's a bit differently from your Instagram example, but if you go on Facebook and you go, the transaction is then happening outside, that they are not responsible. But I think this is a fundamentally important point. Also, I think what Joshua said on the name of the DSA, I think it's a very pertinent point, really, because it is a misleading title if you think about it, and I think we really have to look at that too. On the fundamental rights, I just want to mention that, which I always find very challenging, the question whether consumer protection, we know it's not a fundamental right as such, but it is a principle which is enshrined in the Charter of Fundamental Rights of the European Union. What does that mean? And I think that's really something, because there's so much discussion about fundamental rights in the digital economy that I think it's time for consumer protection to stand up, so to speak, and claim its place. And there, I think the most interesting part of the DSA is this risk assessment in Article 26, where the very large platforms they have to do an ex-ante risk assessment of how their services may potentially affect fundamental rights. And that has to be disclosed. And we are making a point saying you should also do an assessment about how your services may affect consumer rights. So that is going to be a very interesting discussion. And then my last point would be about the whole discussion about safety. And what is the relationship, I call it a triangle, between the Product Liability Directive, the General Product Safety Directive, and the DSA. And that I found Christoph's presentation really helpful also. But what is the right regulatory approach? To be a bit frank with you, we are trying on all ends because we don't know what is coming. So we know that the PLD is going to come in 22, the review. So there we definitely ask, and I think that's a fair point, that in similar ways like you suggested, Joasia, if there is no way for the consumer to get damages because the whole supply chain fails, then it should be the platform. Well, there is, of course, then the question, should that be an asymmetric regulation? Because it should maybe be only for the big platforms. Do we kill the small ones if we do that? But I guess no. But again, this is a tricky question for the overall economic impact of the regulation. And then the GBSD, I really want to see what happens end of June when the proposal will come out. But again, we know that in the in the market surveillance regulation, it's already the obligation to have an authorized representative if it's from a third country, but we know these are often letterboxes only. And so again, it makes total sense that the platform has a subsidiary liability in case this is a fake representative. So this is all very, very connected, and it's difficult to find the best way, but I really appreciate your thoughts on all these relevant things. Thank you so much.
Great. I did not see any questions come up. Would someone like to take the floor at this point? Okay, in that case, I'll move to our next panelist for their reaction and answers, and again, invite our audience to ask any questions in the chat or ask me, and I shall give them the floor as soon as we get a break. So Vanessa, it's over to you now.
Thank you, Christine, and thank you to all speakers for very interesting presentations that give us a lot of food for thought, I think. Joasia, thank you for wrapping that up so nicely and really highlighting where the main points of discussion are. And you also posed some questions that I think haven't been discussed so much. So the digital services as a title for this act, I think you're absolutely right that this is a very broad name for an act that actually covers something smaller. What I'm wondering as we listen to the different comments is whether the act at this stage could still be named something different, and whether perhaps it would also be helpful to focus on online marketplaces specifically. I found it interesting that Christoph highlighted some inspiration from the ELI model rules that is now seeping into the amendments that are being proposed, because the model rules were in fact already much more focused. They also dealt with the liability issue that we discussed in our presentations. So perhaps there is still an opportunity for the European legislator to bring that focus into the proposal, to more clearly define what marketplaces are covered by the DSA and what that means not only for the monitoring regime, which Joasia asked, is that effective? Well, I actually have hopes that that could be effective, but liability rules are still missing. And maybe on those 2 points very, very briefly, the monitoring regime actually, I think, fits very well with fundamental rights protection. That's also what we see when we look at data protection regulation, that there are authorities. So it's a public law regime that seeks to ensure protection. Also for the GDPR, liability is difficult, and there because the harm suffered cannot be quantified that easily. But we see that that aspect is actually quite well covered by public regulation and monitoring. Now for online marketplaces, and that is the part that I elaborate more in the publication that is coming out soon, the Unfair Commercial Practices Directive could actually already provide some framework that could be added to the DSA. The proposal currently doesn't do that. It merely says that it doesn't affect the rules that are already in place. But perhaps there could be an opportunity for the European legislator to add something here that's not currently part of the EuCPD. And that could be rules that on a European level set the conditions for liability of online platforms. If we look at the current regulation, it gives us the misleading unfair commercial practices norms, but the remedies are only specified at a very general level. Some are added in the modernization directive, but the way they are implemented into national laws, you always have to look at the system in which they are implemented. And in some legal systems, that's in private law, so you're looking at tort law conditions for liability. In other EU member states, the EuCPD is sanctioned through criminal law. So there are differences there, and I think it would help consumer protection if we had more clear rules at the EU level. Now, it's also a challenge. We haven't got that yet, and we see that the European Court of Justice has also hesitated to go that far in cases concerning product liability. But perhaps there's an opportunity here.
Great, thank you very much, Vanessa, for your answers and further thoughts. If there's anyone that would like to ask a question, please do so now. It's all very quiet. I think perhaps everyone's put their cameras on. It's very sunny, I know, in many places in Europe, and they've actually been going outside. So without further ado, but once
excuse me, I actually do have a question.
Go ahead.
My name is Stella Pappenberg. I used to work for the rapporteur of the Digital Services Directive in the last mandate of the European Parliament. Ms. Pachl might still remember me quite well. I'm following this now with a bit more distance, the DSA. But my question is regarding the liability regime, because you talked about the difficult situation, Ursula, in the IMCO committee, and that Ms. Schaldemose might not have the support from other political groups to introduce more firm liability. But how is the situation on the council side, if I may ask? Because this is in the further legislative process, this is going to be the main question. Do you see that there is hope? This is a very technical question, but nevertheless, I have the opportunity to pose it here in this distinguished panel. I'd like to take the opportunity.
Anna, I think you were cutting off at times. I wonder if without your camera it might be slightly better. But I do think that some of our panelists did get the gist of the question. I wonder if someone wants to volunteer to answer this. Ursula, go ahead.
Yeah, I think I understood the question of Anna asking about the situation in the Council of Ministers, right? The problem is that I think a leak went out, you know, the Council of the European, well, the European Union's Council is still a closed shop. So you get papers only very late at certain specific occasions when there are political debates or there is a preparation of a decision. So there was a leak, I underline, I think only yesterday, and I have to admit I haven't seen it. My colleague who is working very closely on the file, but I don't think she is on the call. She would have maybe some ideas about what the council is preparing. Of course, we are speaking a lot to the representatives of the member states, but it's hard to say anything concrete before you see the concrete drafting. Maybe just to add that the Slovenian presidency, which will go next as of July, they are very keen to already go for a general approach. That would be surprising, but we know that France is very much waiting for their occasion, and they are quite interesting in terms of the proposals that they make, and I think they could have some sympathy for an expanded liability, at least in certain situations. Let me put it like that. I don't know if that helps, Anna. I'm afraid you were cut.
Oh, I'm so sorry to hear that, but thank you. That's very helpful indeed. That's very interesting. I was hoping it would go that way.
Great, thank you, Anna. And thank you, Ursula, for that answer. Do we have any other questions from the floor at this point? So that gives me an opportunity to continue going through our panel speaker, addressing some of Joasia's comments. So it's now for Catalina to take on some of them and tackle them.
Thank you so very much. I had so much to talk about. It's really a fantastic conversation. So thank you very much for all the contributions. I'm going to build on what Joasia mentioned, which I thought it was really an amazing point. I think perhaps as academics, sometimes we really expect too much from what one piece of regulation can do. And I think that that's a very valid point. In my humble opinion, I think what we're dealing with here is an issue of complexity. So if we're looking at different business models and different markets, the DSA is supposed to be one master that in a way serves everything, but perhaps in doing so, then it fails to serve anything. Because I believe that if we look at the DSA from the perspective, and I think that this has been the main narrative in academic literature so far, the main narrative around the idea of illegal content hosted by intermediaries. So exactly what you were mentioning earlier, right? With the distinction between, are we really talking about providers of digital services themselves, or are we speaking about the triangle, which I believe we can all agree has been a very prevalent structure, right? A very prevalent architecture of business in the digital sphere. And so that's a very valid point. But then if we think about the fact that illegal content has been this idea, okay, is a platform hosting child porn, or is a platform actually promoting goods that can lead to people dying? Those, or is a platform actually, supporting fake Louis Vuitton sales? So these have been these initial questions that the e-commerce has been inherently about, the e-commerce directive, I mean. And now we're moving into this world where, as I was mentioning before, we see social commerce, we see drop shipping giving rise to new eras of entrepreneurship, where entrepreneurship then is going to be in this very, very vulnerable informational asymmetry situation, because a person who has a TikTok account and can advertise their new business, that they're printing journals and they're selling them on Amazon, is not going to have money to invest in legal information, will have absolutely no idea to what extent their rights and obligations will be. So this information asymmetry is really affecting the quality of the services and of the goods that are being provided. What I always find shocking, so if I call it these days, research, but also digital ethnography, to watch a lot of TikTok videos. So if you watch TikTok videos, then you can see that in advertising their activities, a lot of entrepreneurs will say, I contacted influencer XYZ for some sort of advertising, and they consider that just because they have had contact via a direct message, that is not a contract. This is, for me, a symbol of how this information asymmetry works. And the fact that this is the new landscape in which the DSA is supposed to shine light and is supposed to really create some more legal certainty, I think is rather worrying. What I would personally have liked to see in such an instrument that is considered the future of platform regulation in the European Union, and to which perhaps, just in the case of the GDPR, other states around the world will turn to and get inspiration from, was just more linkage to existing regulation. And I think that is something that could have been done and wasn't done. So for instance, here in this example in Article 22 that I gave, why not really just link some very specific rights in additional regulation? And why not create perhaps a sui generis type of transparency for platforms with respect to consumers in respect to these information duties from earlier instruments. So there, if I'm reading this piece of legislation as an academic, of course, and not as a policymaker, I see we also have some policymakers in the room, so perhaps if we can hear from them, that would be also great. But from my perspective, that is either just a very different shift, so a paradigm shift. So we move away from information duties. We don't care about informing consumers anymore, maybe because that doesn't work, as we have seen over time and time again. But we still have these rules. So what are we going to do with them in this new architecture? And the last point that I would like to make, and I really cannot stress this enough, and I have seen this also as a result of an empirical study that I've conducted with Pietro Ortolani from Radboud University. So we looked, and I hope that she's still with us. Emma is still in the room. Emma van Gelder organized a really wonderful workshop last week. So Emma, it would be really great maybe to also hear from you on online dispute resolution. So within this workshop, I was also presenting this research where we looked at 4 different platforms to see what kind of reporting mechanisms are available on 4 social media platforms: Twitch, Twitter, Facebook, and TikTok. And lo and behold, if you want to really report consumer infringements, you don't really have reporting mechanisms for that. And what you have is reporting mechanisms for very much crime-based content. So if it's harassment, hate speech, this is right now what platforms are going to put in their guidelines. But giving consumers the possibility of actually doing something about their rights there, nada. And the problem is also the fact that if you look at it like this, and I think that we were discussing earlier that, okay, let's look at consumer rights from the perspective of fundamental rights. fundamental rights might seem as more moral if we want to think about the way in which, you know, private law and perhaps, human rights interact. However, consumer protection is mandatory. And in spite of this, platforms are completely oblivious of just offering any additional opportunities for consumers to really show that, okay, your consumer rights are being protected. But I'm really very curious, Christina, I don't want to steal more time, but I'm curious if Emma has anything to add about this. And yeah, once more, Emma, great seminar last week.
Great. Well, I see Emma has got a camera on, so
yes, hello everyone. I hope you can hear me. Yeah, so I'm Emma and I'm researching dispute resolution mechanisms offered by online platforms, specifically online marketplaces like eBay, Amazon and Alibaba. And I analyzed the DSA whether or not it could actually tackle these dispute resolution mechanisms, and I'm very curious also to your opinion, but I think the scope is too narrow. It actually points to very specific disputes related to content moderation, not so much to retail disputes like item not delivered or item delivered broken. And I also think the relation which the DSA tackles is more appointed to the platform user rather than buyer-seller. So buyer-seller are not defined in the process regulations. So you have a lot of types of relations, B2C, C2C, C2B, but I don't think the platform buyer or seller relation is tackled. So I think there's a regulatory gap here because the ADR directive and ODR regulation, the scope is limited to certified ADR entities. And it's voluntary, of course, the participation.
Right. So thank you so much. I'm now going to hand over the floor to Christoph for a few minutes since he went over his time. So we are cutting it off here to answer the comments and the questions and what you heard, and then we'll rejoin back just to say thank you all together. Thank you, Christoph.
Yeah, thank you very much for giving me again 2 minutes. I will limit myself to 2 points. One is the point raised by Joasia on this dichotomy between indirect regulation and direct regulation. Maybe I should clarify that I was not suggesting to go for indirect regulation via product liability, but rather a combination of both approaches. I think the EU is missing out by focusing only on direct regulation via administrative enforcement of product safety rules. And this is fine if it keeps rogue traders off the platform and dangerous products away. But what about those cases where the dangerous products slip through and the consumer gets harmed? There, public enforcement doesn't help. You need some claim for damages given to the individual consumers. And I think that is why we need both. And interestingly, we're seeing a convergence between the EU and the US insofar that there is pending legislation in the US Congress that also focuses not on product liability, but on traceability of traders. I'm thinking of the Informed Consumers Act and the Shop Safe Act that have been reintroduced in February and March this year, which are very similar to Article 22 of the DSA. So we see that both approaches are merging here, and I think that is exactly what is needed. That was my first point. And the second point is, I would just add to what Catalina has said about complexity. I think that is really a big challenge, that the online retail landscape is getting so much more diverse, not just social commerce, also live shopping via video. YouTube is becoming an e-commerce place. Amazon Live, where you can see shopping videos like in the old days of shopping TV. And payment services turning themselves into e-commerce places. And that is a nightmare for regulators, because you can no longer think in these silos of regulation, because everything is merging. Audiovisual media, communication, and e-commerce. And maybe the P2B regulation might offer some guidance. Why? Because there's a provision in the P2B regulation that defines the scope of the fairness and transparency rules there. And this provision explicitly says it doesn't matter whether the contract is concluded on the platform or off the platform. They're not using the word platform, but they are saying regardless of whether the contract is concluded there or not, fairness and transparency rules apply anyway. So maybe that could be a model here. And now I stop.
Thank you very much, Christoph. We have a few minutes. So Joasia, do you have one last thing to say about all of this before I wrap up?
I think it was a great debate. I very much enjoyed listening to all of you. And as I said, and as all of you also contributed, it's definitely a work in progress. We'll have to see now what the European Parliament announces, then what further process happens. I think we may want to schedule a follow-up, probably in like a year of time, realistically, because I don't think the process will be concluded, and I'm sure we will have some new rules to discuss, and also then we will maybe be able to link what happens with DSA to the development of the product safety, maybe even product liability new drafts, and I think that will be helpful. There is a bit, as Ursula mentioned, this issue that this is all happening at the same time, and perhaps European Commission has insight into how it will all be linked together. Perhaps they should, but we don't. So maybe what we consider also as gaps at the moment actually is not a gap. It's just something that will, well, is a work in progress, and we have to wait for to hear about it. And there is some master plan about it.
Great. Well, thank you so much to our great audience and our fantastic panel of speakers. I think it's been a very rich afternoon. It clearly indicates that the DSA is a very rich piece of legislation that clearly will keep us all busy. If some of the discussion today and other pieces of research you are conducting sparked your creative juices, please do remember to submit a piece of scholarship that you would like to be considered at the EuCML by our team of editors. We're always looking forward to receiving great contributions. So I'm posting now the email address to do so. Check the submission guidelines online. But for now, I'd like to thank our speakers, and in particular, Ursula Pachl, for taking the time to join us for this really interesting afternoon. Have a good afternoon, everybody. Thank you.